All right, welcome back to another special edition of The Unknown. I am Michael Volpe. I'm in Chicago, Illinois. That's in Cook County, and michaelvolpe.substack.com. That's my website. Richard Luthmann, my broadcast partner, he's somewhere around Fort Myers, Florida, in Lee County, named after Robert Edward Lee. And Luthmann, Luthmann.substack.com. We got an update in the What the Hales case, and very quickly, Jeremy Hales. He is popular YouTuber who likes to sue people for YouTube content. One of the people he's suing is Richard Luthmann, and you have a lot to explain right here, pal. Clerk's default upon application of the plaintiff above, that's Jeremy Hales, in the above styled cause and having examined the records and there appearing to be no responsive pleading filed by the defendant, default is hereby entered against Richard Luthmann Jr. on January 22nd, 2022. This clerk is a really big deal. This is one of the most important clerks ever. Okay, she misspelled your name. That happens. You're screwed, buddy. We're done. Should we just turn off the video? And you have no way to explain this, do you?
Well, that's the first point right there. I don't know who Richard Luthmann Jr. is.
You're
Frankly,
trying to wiggle out on a technicality. That's not going to work. You're
well,
screwed.
that's the law for you because it's actually due process. You have to have notice of being sued. And when there's somebody named Richard Luthmann, myself, and they've served already another Richard Luthmann in the state of Florida, and they've misspelled Richard Luthmann, and they don't give notice to what Richard Luthmann they're talking about. And the operative pleading, go back to the top, Mike. Go back to that top. That's the caption of the case. In the case, what's the
Right.
name that they have in the caption? The last name right before the defendant's last name of the
Luthmann,
defendant.
Luthmann, no junior or senior. You are junior. I interviewed you and your dad. You guys have the same name. So you got to do, well, you
No,
don't
we
have to
don't.
do
He's
junior
a
and
senior,
senior,
and I'm
but
a
you do.
junior.
Right.
Well, but that's the point. The point is that in
All
the
right.
complaint,
All right. So
they said
you
I'm from New
threw
York.
a 28-page Hail Mary. There's no way this is going to work because as I saw in the beginning, you're screwed. But you're going to throw yourself on the mercy of the court. Is that right? You're basically going to beg the court for forgiveness. Is that the proper way to sum up what's happening in these 28 pages?
Not really. I'm actually making a limited jurisdictional appearance, which means I'm
Oh,
not
whoa,
appearing.
whoa, 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 whoa. That's like 4 words with like 12 syllables. Limited jurisdictional appearance. How about you explain that for people who aren't snotty lawyers?
Okay. When you go to court and you answer a case and you show up, you make what's called a general appearance. If you do nothing, you make a general appearance. You're consenting to the jurisdiction of the court. You're consenting for the case going forward on the merits of the case. I'm making what's called a special appearance, a limited jurisdictional appearance, and I'm telling the court in at least 4 or 5 different ways why the court shouldn't hear this case because jurisdiction has not been acquired over me, Richard A. Luthmann Jr. And
Uh-huh.
so that's what this whole document is about. It's
All
why
right.
there's no
I
jurisdiction.
think we need to go back. We've done the Tarantino. We've given the audience the really highlighted piece. We got them to the coffee shop, as I like to say from Pulp Fiction. But let's go back. So first of all, this lawsuit is nearly a year old. You were added in April. The lawsuit is basically a bunch of people said mean things about Jeremy Hales, and he doesn't like it, so he's sued. The judge, who's a magistrate, Zachary Belido, should have a long time ago said this is ludicrous and frivolous and dismissed it, but he has allowed for a lot of machinations. You were added late, so I guess that's part of the reason why it took a while to serve you. Initially, he served, so to speak, your dad, but he didn't even serve your dad. He served, I think it's his wife. And then they tried to say that that was you, and then your dad entered an appearance or he filed some things.
Well,
So that didn't go anywhere. What happened after all of that craziness?
let's talk about the timeline. We'll talk about the foundation that you like so much, Mike. You said about a year ago this case got filed, and then what Jeremy Hales' side did was they amended the complaint. They amended the complaint the first time in April 28th of 2025, to add additional parties, including Richard Luthmann, the person that they put in there. And then again, they amended the complaint in June. of 2025 to put in additional claims and to put different things. So we're on what's called the second amended complaint. That is the operative pleading in the case. That's the case that everybody has to answer or respond to. And so there are a couple of events of independent significance that happened prior to that filing of that April 28th second amended complaint that first contained the name Richard Luthmann in it. On April 23rd, which many people may know, I have a lawsuit against a man named Dinesh Nishirvan. And you can see some of the stuff that Mike and I have talked about with that case. I filed on April 23rd, a week before, in the Florida federal court system, totally researchable and viewable on Pacer, with my address. I put my address in the federal court system, open and notorious to anyone who might use Pacer, including a federally barred attorney like Randy Shaka. In addition to that, 3 years before that, in 2022, I filed under Florida law what is called a declaration of domicile. And that declaration of domicile says, I'm Richard Luthmann. I formerly lived in New York, but I now live in Collier County in Florida. And I made that and I filed it with the clerk, and that's readily ascertainable from the court. So what happens is those are both important facts, and it's in part of this analysis because they bear the risk, Jeremy Hales and Randy Shaka, of their pleadings not giving notice to the party. So
if you hold on, if you know, have they ever shown up to the address that you have listed with the courts? Have they ever shown up? If you know,
yes, they claimed, and Michael, you know this. When does hurricane season span in the state of Florida?
Like late summer into fall.
So you'd say like July, August, and September would be hurricane season, right? Would you say that August would be like the height of hurricane season?
Yes, let's say yes.
Okay.
I think September is.
There was an attempt by a process server to come to my house at the height of hurricane season in August. They came 2 or 3 times. Nobody was there. I never received anything. But they claimed in the affidavit that there were storm shutters on the house and it looked abandoned, or that nobody lived there because there were hurricane shutters up on the house during the height of hurricane season. That was their full thing. They never came back to the address. Even when they went to the court claiming they couldn't serve Richard Luthmann, they never came back to my Naples address, to my Naples residence, and they never tried to serve me there. Even after I've told Randall Shockett and Jeremy Hales and Doreen Turner Incolis in emails, this is where I live. They said, no, we served you. You've been served. When my father was served in Jacksonville, they didn't. And then they tried to serve the Secretary of State of Florida. They got permission from the court to do so.
Hold on. Why would they try to serve the Secretary of State of Florida?
Well, you have an ability to serve the Secretary of State, but there are 3 elements that have to be in place. Okay, one is the person has to be a non-resident of the state of Florida conducting business in the state of Florida.
Okay, right? Now if you have filed this domicile thing and then also filed into court in another case that you live in Florida, how can they claim that you live in New York, in the state of New York? And that's what they're claiming.
And in addition, well, that's just it. I think it's another Richard Luthmann they could be looking for. I don't even know what this means.
Oh, well, so they might be confused.
They could be confused. I'm confused. They've confused me. I get confused very easily, Michael. So the problem we have here is that there are 3 elements. One is that somebody who who resides in another state but has a business interest in the state of Florida. So that is not me. I don't live in New York like they say that in the complaint. They're probably looking for another Richard Luthmann. I might have a long lost cousin named Richard Luthmann in New York that's carrying on business in Florida that I don't know about. I don't know this fact. There's another Richard Luthmann in Florida, my father. So that's one point. The second is if you're a resident of Florida and you're evading service, right? So if they have to prove that they know that I'm a resident of Florida and that I'm evading service, but they say in their complaint number 1 that I'm a resident of New York. So the evasion of service doesn't matter, okay, there. And number 2, I have given to Shockett and Hales on numerous occasions by email, and you've been copied on a bunch of them, my address, pleadings with my address, notice to them, let's try to resolve this. I want to do this. Let's resolve. And they didn't even change course at all. They didn't course correct in any way. And the number 3 is
let me just interrupt you. Let me just interrupt you. The reason they wouldn't change course is because their goal is not to resolve anything or to move anything forward. Their goal is to create something legally that can be turned into YouTube content. And so they don't want to resolve anything. They want this this default entered in by a clerk. And they have had, I think, about 10 of these among all of the cases that they have filed. And each one has eventually gone away, but not before they did at least one and sometimes more than one show on it. And so for Jeremy Hales, it is profitable to say here is a default because he'll make several $1,000s on that. The default will go away. I guess his fans don't notice that none of the defaults stick around, that you keep saying default and then it's reversed. But that's why they don't want to respond to you or resolve it, because the whole idea is polymop, as Bruce Matskin would say. Go ahead.
They're 0 for 6 on these claimed defaults, I think, from my count. It could be more, but they run around and they say, we got him, default, we win. Now, let's assume for a second that he did win, right? And he got a default on me. What the case happens at that point would go to what's called inquest, right? So Jeremy Hales would have to come to court and have to prove his damages, and I could still go to court and argue against his damages. He has $0 worth of damages. He cannot prove that Richard Luthmann's actions in any way, shape, or form caused him harm. In fact, I probably gained him money, right? I probably made him money, number one. Number two, it's a deceptive trade practices claim, right? Unfair and deceptive trade practices, both on the state and federal level. It's really speech. So speech can't be a deceptive trade practice. So there's a category of damages they can't even establish. So if he wants to say that you're defaulted, Luthmann, then I'm going to say, well, okay, that's fine. You get $0. So, that's fine. I'm cool. You win, okay, $0. I win, you fool. And so I'm expecting him to parade and like a rooster with his chest popped out on Sunday night, because that's all he's got. Patience. That's all he's going to do.
He's used all of this to make money. That's correct.
Yeah, he's using all of it to make money. And the fact is that if we assume that he's right, Mike, if we assume that he's right and that he has the diversity of jurisdiction, he's going to say Richard Luthmann, the New York resident, as per his complaint, he doesn't have $75,000. Remember that from the other Fed 1, the $75,000 threshold in court.
Right.
I can make it from the very beginning of inquest say, no, he doesn't have $75,000. The court doesn't have jurisdiction to award him any money.
Let me interrupt you. You put in a bit of context that I think is important about Randall Shockett, and you say the court is not writing on a blank slate with respect to the counsel's obligation of truthfulness and candor. As reflected in a published decision of the Supreme Court of Arkansas, Shockett versus Arkansas Board of Examiners, which you attached as an exhibit, attorney Randall Shockett was previously found to have engaged in conduct involving fraud, misrepresentation, and perjury in a professional licensing context. What are you talking about there?
Randy Shockett was a dentist in Missouri, right? And he was a very, very bad dentist, because he would double and triple bill for procedures, and he got caught with very, very terrible billing fraud with the insurance companies up there. And he lost his Missouri dental license. While he was suspended from Missouri dentist, and while he was going and contesting it, he was still working as a dentist under somebody else's license, and he violated the licensure laws even further, to which they totally revoked his dental license. So what did he do? Well, he decided to become a lawyer. Okay, he's not going to stop pulling teeth. He's going to start screwing people for a living. So what he does is he goes to law school, and then he applies to become a dentist, because to become a lawyer in the state of Arkansas. And the Arkansas Supreme Court says, not so fast, my friend. There's no way you're going to become a lawyer in the state of Arkansas, given your dishonesty. So what does he do? He waits a couple of years, and he tries again in Florida. And Florida says, oh, come on down, Mr. Shockett. You're now a lawyer in the state of Florida.
One other important thing is he was not completely honest with the state of Arkansas about everything that he did as a dentist. Now, you put this in the context of Randall Shockett, I would say committing perjury, because he put a lot of things into legal documents that are sworn in under oath. So that would be perjury. So what were some of the lies that you listed in your in this motion that Shockett made under oath, or as many as you can think of? regarding
And
you.
it's not, and it just as a caveat for the audience that might find this interesting, it's not just perjury. I'm going for a lesser standard as well as perjury, but the lesser standard is in a case with two little known people, Trump versus Clinton. And
Mhm.
Donald Trump sued Hillary Clinton and the DNC and everybody else in the world in Tampa in the federal court. And they
Mhm.
dismissed the case that Donald Trump brought, and they sanctioned the lawyers in the case for what's called lack of candor to the tribunal. They said that Trump's lawyers and even Hillary's lawyers, to a certain extent, were relying on facts as they were pled in the beginning of the case. And as certain facts came out, they didn't course correct, they didn't adjust. They didn't
Mhm.
have candor to the tribunal to tell the
How
court that,
how
that
what how is that related to this case? What did you find in
well,
this case that was
that's the honesty and truthfulness that Randy Shockett has to have. You filed a grievance against Randy Shockett based
I
upon
did?
his case towards the tribunal, and this is a pattern of behavior that he has. Where when facts change, like he's alerted to Luthmann's address in Florida, that Luthmann's a resident of Florida, he doesn't
All
tell
right,
the court,
so
oh,
if basically if I understand it, if Shockett put in a motion or something like that, put it in a filing saying that Richard Luthmann lives in New York, so we want to do a Secretary of State's service. And then you alerted him that you do not live in the state of New York, you live in Florida. So the way you're doing it is wrong. And rather than correcting the record with the court, he sat by and did nothing. Am I right?
that's the
And
point.
that is
And what happened?
similar to the grievance I filed with the state of Florida that was dismissed, where he claimed that a woman, Martin, was working in both Florida and Ohio. And I said, no, she works for Levy County, Florida, and only that you need to correct the record. And he ignored that as well. So he has a pattern of saying things that are wrong that maybe he just got them wrong, but refusing to correct them once he is alerted to the factual error, which
Yeah, and
is very bad, folks.
it's what's called the transformation of something that's a procedural, irregularity or procedural mistake, and that's understandable. Nobody's perfect, but after the procedurals happen over time, it becomes what's called substantive fraud. And so I
Mhm,
sent him at least 7 notice emails, letting him know facts, letting him know things, and he didn't
mhm,
course correct, he didn't change anything, he didn't alert the court, and that's why he hoodwinked the clerk.
mhm.
That clerk's the fault, and that
I
clerk looks like a fool right now because she signed off on a clerk's default that should never have been signed off
I
on because
I
it's all
have a question for you.
uh,
After Zachary Beliveau, and I'm sure it'll take a while for him to read it because 28 pages, that could be a month before he reads this thing. After he reads it, does he have an ethical duty to alert the bar to this pattern of deceit that he
well,
has seen, assuming that he checks, he investigates and makes sure that you're accurate and
a,
learns that you are correct? Does he have an ethical duty to alert the bar to this pattern of deceit?
a judge has wide latitude within the inherent powers of the court to fashion a remedy or a sanction against a party or an attorney. And I
Mhm.
asked the court their inherent powers to do whatever they want to do, and there's plenty there for them to do. I specifically asked for the sanction, but I said the court has the power to do it. And
Mhm.
so, what usually happens in this case, Mike, is 14 days from the date that this was filed,
Mhm.
Randy Shockett has to file a response
Mhm.
pursuant to the federal rules of civil procedure.
Mhm.
Additionally, the court can make a ruling on the motion. They could grant my motion, deny my motion. They
Mhm.
could stay my motion, or they could order further briefing or an order to show cause by Randy Shockett to say why he shouldn't be referred to the bar for discipline,
Mhm.
or why he didn't violate the rules of professional conduct related to attorney candor. That's normally what happens from a professional ethics standpoint. If they're going to do something with it, they'll give the opposing counsel a chance to respond on it. And I think that Shockett's going to respond on it when he has to put in his opposition in 14 days or less than 14 days now. But if the
And
court really
we
wants
hold
to
on, let
do
me
something,
interrupt you. We should note, according to the stamp, it was filed on the 28th, so 2 days ago. He's got, I think, eight more business days. Go ahead.
no, he's got 14 days from the date of the stamp.
Right. So 10 business days.
Yeah.
Yeah. So less than 2 weeks. Go ahead.
Yeah, so in a couple of weeks, it's right before Valentine's Day, he's going to feel all warm and fuzzy inside when he's going to have to
Mhm.
explain to the court why he didn't violate the rules of professional
May-
conduct. Now,
Maybe his
that's a big
paramour will
issue.
write it for him. Maybe his paramour will write it for him.
Yeah, who knows?
Doreen
Maybe.
Turner Inkles. All right, go ahead.
And
So,
so that's the issue. Now, the other part about
so
this is
basically, I really want to use this. You are in effect arguing "liar, liar, pants on fire," to
I
quote
am.
from one of the more famous lines from A Few Good Men. But you, in effect, what you have laid out is here are all of the mistruths that Randall Shackett gave you in order to convince you, court, that one, that I was evading service, which I was not. Two, that I was properly served, which I was not. So he only did that through a series of lies, a lack of candor, and then if the court agrees with you, then what are you asking the court to do?
Well, I want the court to dismiss the case, A, on the lack of service, okay? But if you
Mm-hmm.
go back up a little bit, right,
Mm-hmm.
there's a couple of other technical points there, too, right there. The alternative dispute resolution. Keep going up. Keep going
Right
one more.
there. All right, let's read
Yeah,
it.
but there's 20, 28, 23. 23 starts the alternative dispute resolution.
All right.
That's 24. Go to 23.
Okay. From the man who wanted, what did you want to do again? Trial by combat. This is another alternative dispute resolution. Independently and dispositively, defendant notes that the underlying dispute between plaintiffs and defendant is governed by a binding and enforceable alternative dispute resolution agreement as memorialized in written communication dated October 17, 2025, and reaffirmed on October 31, 2025. The parties expressly agreed to submit all disputes, claims, and controversies between them to final alternative dispute resolution pursuant to the Federal Arbitration Act of 1925, as amended FAA. Under Florida law, a valid contract exists where there is an offer, acceptance, consideration, and mutual assent to essential terms. And then you cite some cases, very boring. Florida courts apply an objective theory of contracts under which a party outward manifestations, not subjective intent, control whether an offer has been accepted. You cite some more cases. Here, the party's action, statement, and written communication demonstrate a clear meeting of the minds, objective assent, and mutual consideration sufficient to form a binding alternative dispute resolution agreement under Florida law. Plaintiff Jeremy Hales made an unequivocal offer, which defendant Luthmann agreed. Okay, you have a YouTube video. We're not going to watch it, but tell us what offer did Jeremy Hales make in this YouTube video?
Well, he said, if he wants to, he wants to do the trial by combat with me, and
He
so
wants to do trial. Okay, but hold on.
He offered to do trial by combat.
I don't
and
think.
So I accepted that offer. I accepted the offer in writing.
Hold on. Maybe in the 17 and 1800s, we could do a duel a la Alexander Hamilton and Aaron Burr. But I don't think that Magistrate Zachary Belitho, no matter how much of a bozo he is going to order the two of you to go into a field and shoot each other. So obviously that was made in jest. So there's no real deal here.
No, because if you look at it, it's objective. It's not what somebody might think. And if you look at the communications between the parties, I had outlined all the things that we could do as an alternative dispute resolution trial by combat, and it also specifically included a court sanction. So we're going to ask the court what they will sanction. Okay, the reason why Alexander Hamilton and Aaron Burr had to go over to Weehawken in order to have their duel, and they're both from New York, is because in New Jersey at the time, a duel by prior agreement was legal in the state of New Jersey, but it was not legal in the state of New York. But what was legal in New York at the time was a duel by judicial sanction. And a duel by judicial sanction still remains part of the common law of the state of Florida.
Right, hold on.
What the court can order and fashion a remedy for us under our agreement to alternatively dispute, have alternative dispute resolution.
All right, so what are we talking about? A water balloon fight? What can the court order as a
It
duel?
could be it could be paintball, it could be arm wrestling, it could be American Gladiators, it could be a whole bunch of things. So
Ah,
we'll see what we're gonna do.
all
You
right.
know, it could be
Can he order a boxing match with those like massive gloves that they used to
yes,
do for? Yeah. All right. All right.
anything. Now,
So
they've read the second part, Michael.
you're
Wait, read
asking Bozo Bolivo to order this alternative dispute resolution where you guys get into.
we'll see if he gives it to me. But the point is that I have the right to go up to an Article 3 judge. And so the Article 3 judge, in this case, after, if I don't get what I want from Malito, I can do a Rule 72 objection, have the Article 3 judge hear this. And there's enough legal issues here. If I don't get what I want from the Article 3 judge, I can go to the appeals at the 11th Circuit and make a case out into the 11th Circuit up in Atlanta. Now, that second point right there about the arbitration, Mike, is a very important point, because there's another contractual or quasi-contractual portion of the law of the state of Florida called equitable estoppel. And so the equitable estoppel says whether or not there was a valid contract, if I relied on the fact that Jeremy Hales held out that he would do trial by combat, and I did it to my detriment, then he cannot deny the Federal Arbitration Act agreement to alternative dispute resolution. And as you well know, Michael, he had a couple of his polymorph episodes where he was showing what he was going to do when he had fatty paint chips in trial by combat. So those statements made in the press, those statements made very publicly, create what's called equitable estoppel. And so he's under contract law of the state of Florida, is unable to get the weasel out of the arbitration contract to finally,
Only Richard Luthmann can throw in trial by combat, the Federal Arbitration Act, and and what was it, estoppel?
Equitable estoppel.
Yeah, in the exact same sentence. All three of those terms in the exact same sentence. Good job. That is impressive. Yeah. All right. Okay. Go ahead. So besides that, what's the rest of the argument you're making? And also, I think this is an important argument. Claims lack merit. Substantively, you say, finally, although the court need not reach the issue given, the dispositive jurisdictional and service defects, defendant maintains that the second amended complaint fails to state a claim upon which relief can be granted. The pleading is rife with conclusory allegations and does not set forth a cognizable legal theory against defendant. Should the court entertain the substance of the claims, the defendant is prepared to demonstrate the plaintiff's cause of actions are inadequately pleaded, shotgun pleading, and legally deficient under Rule 12b-6. Whoa, there's like 15 words with at least 4 syllables. Explain that.
Well, we had a show before when this case was first filed where we talked about the shotgun nature of the pleading. And the 11th Circuit especially, there's sticklers under the pleading standard. There's two cases, and Iqbal, and both of those are Supreme Court cases, and they talk about what needs to be said and the particularization that needs to be said in federal pleadings. And so part of that, the case law in the 11th Circuit is that you cannot have what's called a shotgun plead. You can't throw it all against the wall and then say to see what sticks. You have to particularize the claims that you're making and as against each defendant. So when you have a case like this where there's a broad conspiracy,
right,
you have to particularize.
Hold on. You made an outrageous video where a photo of Jeremy Hales receives oral sex from a photo of my former friend Megan Fox, and it hurt Jeremy's feelings, and you hurt Jeremy's feelings, and you should pay. So I don't know what you mean by shotgun pleading, but that sounds pretty bad, and you do not deny making that awful video.
I'll tell you something. There was no meretricious conduct. There was no sexual conduct that was on the four corners of that screen. It's all in your mind, Michael. You have a sick mind. What I'm trying to say on that?
Technically, you are presuming that the photo of my former friend Megan Fox, as opposed to the other more famous Megan Fox and other Megan Foxes that may exist, was giving a blowjob to Jeremy Hales, though that doesn't actually show. There is a slurping sound. I'm not sure what she was doing with that, but it is a photo. But that hurt his feelings, and if you hurt his feelings, you should pay. I'm sure the law says if you hurt Jeremy Hale's feelings, you should pay. Am I right? There's a law somewhere that says that, right?
If you go to the end of this, there's a paragraph the very bottom of this. Go to like page 25 or so, and it actually addresses that point specifically. And what there is something in the law called a private cause of action. Go back up above the conclusion, right before the conclusion. Let's see, right here. Okay, yeah, paragraph 52. You can read that. Read that. It answers it.
Count 16 fails as a matter of law because Florida's sexual cyber harassment statute, and then you cite the number, is a criminal statute that does not create a private right of action. Under Florida law, in determining whether a statute creates a private cause of action, legislative intent is the controlling factor, and courts will not imply a civil remedy where the legislature has not expressly provided one. Section blah 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 contains language authorizing civil enforcement by private litigants and instead vests enforcement authority exclusively in the state through criminal prosecution. So they argue that you were engaged in cyber harassment, but that is a criminal statute with no civil remedy. And the reason they won't go to the cops is because possibly then the cops would arrest them for filing a false complaint. Because obviously it's not cyber harassment, it's satire. I was trying to be satirical. It was ridiculous that he put that in there. I'm sorry you're feeling. I don't even think his feelings are hurt. I don't think Megan's feelings are hurt. I think she sees this as a content bonanza and pretends like her feelings are hurt. Same with
what I can tell the audience is we're debuting a new term today, because if Judge Bolitho or Judge Hinkle decide that the complaint goes forward as is and I have to answer the complaint, I will promptly be filing a counterclaim under the Florida bestiality law, because Jeremy Hales is a crocodile copulator. That is our new term. Jeremy Hales, the crocodile copulator. Yes. And so I would have, if they have a private cause of action against me for cyber stalking, which is a criminal statute, then I have a private cause of action against them for crocodile copulation in violation of the Florida bestiality statute. So they would be bestialists. I don't know what the word would be. People who perform bestiality. They would be crocodile copulators. And so we're looking forward to that.
If you have sex with an animal besides human, that the technical term is bestiality.
Yes. Crocodile copulators.
And, so we have presented quite strong evidence that he does have sex with alligators. In fact, we're not certain that his girlfriend is not an alligator. Sometimes she looks like one. She could be like
a creature that could live in the swamp.
Right. Yeah. She could be like in that movie Splash. She could be half alligator, half woman. It could be that. All right. Anything else? So anything else you want to add, or maybe conclusion? Here is your closing argument. Win the motion with your closing argument.
Well, go down to the relief requested. You were just there, like page 25. And we'll just go through the relief that I'm requesting from the court. And it's pretty straightforward.
All right.
And
hold on.
Why don't you read that? That's the page. You just had it, Mike.
Right here?
Here we go. Yes.
All right. Vacature of default. Enter an order vacating the clerk's default entered against the defendant. Dismissal for lack of jurisdiction. Dismiss the Second Amendment complaint as to the defendant, Luthmann, due to lack of personal jurisdiction, insufficiency of process, and service of process. Enforcement of alternative dispute resolution agreement. In the alternative, dismiss this action and compel plaintiffs to resolve their claims against defendant in accordance with the Federal Arbitration Act, the parties binding alternative dispute resolution agreement, and or legal doctrine of equitable estoppel. Dismissal for failure to state its claim. In the alternative, dismiss the Second Amendment complaint for failure to state a claim, upon which relief can be granted. Other relief, award any and further relief the court deems just and proper, including but not limited to an award of costs and fees to defendant to the extent permitted by law for having to bring this motion sanctions, including attorney referral to the Florida bar pursuant to the court's inherent powers. Defendant, all right, that's it. All right, so you ask for the bozo magistrate to refer him to the bar. He should be referred to the bar. I've rarely seen a lawyer engage in this much deceit, like the catch-all between fraud and perjury and other forms of deceit in this short a period of time. And he has not been held accountable by the bar yet. And it's, there's a common perception that lawyers lie. There's some reality to that, but not to this extent. Lawyers don't engage generally in just this constant form of deceit. Maybe they take cut a corner here and there, but not to this extent. And he should be not just sanctioned, but he should be removed from the bar. No one in Florida should want this guy practicing. Nothing that he says is truthful, and he knows it's not truthful. Any last thoughts?
Pattern of behavior, Arkansas Supreme Court, but also the Florida courts have referred him. There are a couple of judges that have had some really, really sharp referrals and rulings about his conduct in the insurance, as an insurance lawyer and doing other things. So this guy's a bad seed. That's the problem. And you put together a narcissistic, almost psychopathic client with a ton of money, like Jeremy Hales, and a lawyer with no ethics. You have a very bad combination that's going to hurt the public, going to hurt the consumers of legal services in Florida, going to hurt the elderly. We see that with Ray Bonecrusher, whose wife recently died. People don't belong in federal court. There's the phrase, Mike, don't make a federal case out of this. Right. And he's making a federal case out of things that shouldn't be there, because there are people that shouldn't be in federal court, because it's creating real problems for them. So unless the court punishes Jeremy Hales and punishes the lawyer that's aiding and abetting Jeremy Hales and enabling Jeremy Hales, this type of behavior is going to continue.
I agree. And your last statement, that's why this is important. That's the part of the story that I'm trying to get people to understand. You have a very wealthy, powerful, and unethical person combined with a very unethical lawyer. And it appears a lot of judges who don't seem to care or don't seem to notice what is happening. And it's creating a bonanza for them. All right, we will be back soon with more on the Hales case.